In the last lesson, we studied when a contract would be repudiated by express words that unequivocally stated a party would not perform, or by actions that were fundamentally inconsistent with performing the promise. Now we're going to take a look at when a contract can be repudiated by failing to give assurances when another party has reasonable insecurity. Just a quick review before we go forward. Repudiation is the refusal to perform a contractual duty before the time for performance is due. If the time for performance has already come and gone, we instead would analyze whether there is material breach or total breach. So, before the time for performance is due, the promisor may unequivocally disavow any intention to perform when the time comes. That would be an express repudiation, also known as a renunciation. Or the promisor could take an action that's fundamentally inconsistent with the performance. Like if I promise to sell my house to you on Sunday and you find out on Thursday that I've sold it to someone else, that would be a repudiation by action. Restatement section 251 gives us the provision for when a failure to give assurances may be treated as a repudiation, where reasonable grounds arise to believe that the obligor will commit a breach by non-performance that would of itself give the obligee a claim for damages for total breach under section 243. The obligee may demand adequate assurance of due performance, and may, if reasonable, suspend any performance for which he has not already received the agreed exchange until he receives such assurance. What is the restatement trying to say here? The restatement is providing an avenue for a party who is given uncertainty about a contract to remedy that uncertainty. And the reason for that is being uncertain about whether your benefit of the bargain will occur under a contract is itself a type of harm. Let me give you a simple example. Let's say you had a contract to work in New York City for a year starting this summer. What might you do in reliance of that promise? Well, you might get an apartment in New York City. But if you were uncertain that that contract was going to go through, you might be hesitant to rent an expensive apartment in a city you had no other reason to move to. And how could that harm you? Well, by waiting several weeks or months to go and look for an apartment, you may end up with a worse apartment or a more expensive apartment. Meanwhile, while you're in the state of uncertainty, you're not sure whether you should be trying to find some other gainful employment for the following year. So the restatement is trying to balance that need for a party to get certainty in certain cases with not letting the party off the hook simply because they're unsure about the other's performance. Let's take a look at a couple examples that should make this more clear. First, we'll look at what are reasonable grounds for insecurity. Then we'll look at what are reasonable demands for assurances. And then we'll look at what assurances are adequate. Let's take a look at a relatively simple illustration and see whether the requirements of section 251 are met. Illustration 1. A contracts to let B use his concert hall on the evening of May 7 for a performance by B's string quartet, in return for B's promise to perform and pay A percentage of the receipts. The contract provides that B is not discharged even if he is unable to transport his quartet to A's hall. On May 6th, because of an unexpected airline strike, A reasonably believes that B's quartet will be unable to come the 3,000 miles necessary to perform in his hall as scheduled. Without demanding adequate assurance of due performance under the rules stated in this section, A then contracts with C to let C hold a meeting in the hall on the evening of May 7th. A's contract with C is a repudiation of his contract with B, which gives rise to a claim by B against A for damages for total breach. What does this illustration show us? This illustration shows that even if you have very reasonable insecurity about your party's inability to perform, for example, here there's a very high likelihood that a string quartet will not make it 3,000 miles without being able to fly in an airplane. It's very reasonable to believe they won't make it to the performance date. You still need to make a demand for assurances. Otherwise, you can't stand on Restatement Section 251 and find that the party has breached by failing to give you those assurances. What is the nature of this demand? The demand does not have to be in writing, but it has to be clear and it has to be reasonable in relation to the uncertainty. Illustration 3. On May 1st, A contracts to sell and B to buy a parcel of land for $50,000. Delivery of the deed and payment of the price to be on July 30. Unknown to both A and B, C has a dower interest in the land. Basically, a dower interest is just a way of understanding that the title is not clear, that in fact this land cannot be transferred in fee simple with a clear title in the way that the parties had expected. On May 15th, B discovers this and demands that A give him adequate assurance of due performance. A fails to do so, and B commences an action against A on July 1st. How is illustration 1 and illustration 3 distinguishable? Well, first, how they are similar is that they both have a circumstance where it is reasonable to have doubt about your counterparty's ability to perform. On the one hand, it's unlikely a party is going to make it 3,000 miles in a day without the ability to fly in an airplane. On the other hand, it's unlikely that you can sell land with clear title where that title is obscured by a dower interest. Now, how are these illustrations different? In illustration 1, there was no attempt to demand adequate assurances from the other party, and here there was a demand made. Of course, in both cases, there would be no ability to give reasonable assurances, or at least no obvious ability to give assurances. But what is the distinction between illustration 1 and 3 telling us? The distinction between 1 and 3 tells us that the demand is a required part of the elements of the 251 provision for adequate assurances. B had reasonable grounds to believe that A would commit a breach by non-performance that would of itself have given B a claim for total damages for breach. In other words, B had good reason to believe that A was not going to be able to materially perform the contract, and in fact would never be able to materially perform the contract because of this dower interest, which equates to a future total breach, a prospective total breach. If the court concludes that a reasonable time for A to give adequate assurances had passed on July 1st, B properly treated A's failure to give assurances as a repudiation. So this is similar to the cure period concept that we discussed in material breach and total breach. Remember that the difference between the legal effect of material breach and total breach is in material breach a party can withhold performance but cannot cancel, not for a reasonable time, known as the cure period. Only at the expiration of the cure period can the party cancel, when we enter a state called total breach. Similarly here, during the period where a party has the ability to give adequate assurances, the other party cannot yet terminate the contract. It has to wait for those assurances to either come or not come. Once a reasonable time has passed, however, the party can then declare the contract terminated. Returning to section 251, let's take a little bit of a closer look at what would constitute an adequate assurance. And we'll return to the same facts as illustration 1. In illustration 6, A contracts to let B use his concert hall on the evening of May 7 for a performance by B's string quartet in return for B's promise to perform and pay A percentage of the receipts. The contract provides that B is not discharged even if he is unable to transport his quartet to A's hall. By the way, this is a concept called a force majeure provision, and it shifts the risk of an uncertain event from one party to the other. We'll talk about force majeure provisions in another lecture. On May 6, because of an unexpected airline strike, A reasonably believes that B's quartet will be unable to come the 3,000 miles necessary to perform in his hall as scheduled. In other words, A has reasonable grounds at this point to believe that B is going to breach because it's unlikely that a party will travel 3,000 miles in a day without the ability to fly in an airplane. Now we're going to change the facts between illustration 1 and illustration 6 as follows. In illustration 6, A telephones B on May 6th and asks B to assure him that he will be there on May 7th. This now is a demand by A for assurances, and A has now met A's obligations under Section 251 to make a demand. Let's see what B replies. B says only, "We will do our best to get there." And the restatement tells us that this is not an adequate assurance, that we will do our best to get there under these circumstances where it's 3,000 miles and there are no airline flights. is not going to assuage A's concern. Since at this point the reasonable assurances have persisted for a reasonable time and demand has been made and the reply is not an adequate assurance, A can now cancel the contract. Section 251.2 goes on to describe the legal effect of what would happen in the case where adequate assurances are not given even though a reasonable demand was made. The obligee may treat as a repudiation the obligor's failure to provide within a reasonable time such assurances of due performance as is adequate in the circumstances of the particular case. The relationship between the parties, the prior dealings they would have, the reputation of the party whose performance is called into question, the nature of grounds for the insecurity, and the time within which the assurances are to be furnished are all relevant factors in determining whether or not a reasonable time has passed. What is a reasonable time will depend on the particular circumstances, so we need to look at all the facts and circumstances to see how long a party has to wait. This is a similar concept to that specified in Section 242, which says that whether we determine that there is a material breach or a total breach depends in part of whether there would be harm from the delay and whether time is of the essence in the contract. Similarly here, whether or not a obligee may treat a failure to provide assurances as a repudiation depends on facts and circumstances like whether delay would cause further harm. Now that we understand when a failure to give adequate assurances will be treated as a repudiation, let's return to understanding what is the effect of a repudiation. Repudiation has the same effect as a total breach, where an obligor repudiates a duty before he has committed a breach by non-performance, and before he has received all of the agreed exchange for it. His repudiation alone gives rise to a claim for damages for total breach. Again, the effect of a repudiation is the same as the effect of total breach, and it occurs as soon as the repudiation is made. Where performances are to be exchanged under an exchange of promises, one party's repudiation of a duty to render performance discharges the other party's remaining duties to render performance. In other words, the effect of a repudiation is instantaneous. At the moment that you are repudiated against, you are thereby relieved of any further obligations under your contract. This was shown in the famous old case of Hester versus De La Tour. In that case, an individual contracted with a tour guide to give him a tour, and the individual then, before the tour was to begin, much before the tour was to begin, called up and said that he wasn't going to go. And you should read this famous case. It has a lot of interesting details in it, but bottom line, what was the effect of that phone call? The tour guide was immediately relieved of his obligations. When the person taking the tour called and said, "I'm not going on the tour guide thereby was immediately relieved of his obligations and could go and book another client for that tour. In conclusion, on the topic of reasonable insecurity and adequate assurances, circumstances can give rise to one party's reasonable insecurity about the other party's ability or willingness to perform under a contract. By reasonable insecurity, we mean that a reasonable party in a similar position would feel insecure. When this occurs, the insecure party has the right to demand adequate assurances from the party whose performance is in doubt. This demand must be proportional to the insecurity, and it can account for circumstances, such as the party's reputation. An insecure party must make a demand upon the party whose performance is in doubt before declaring the contract repudiated. The party whose performance is in doubt has a reasonable time to provide adequate assurances. Under some circumstances, it would be difficult or impossible to provide these assurances, but a demand for them must be made regardless. If the party whose performance is in doubt cannot make adequate assurances within a reasonable time, the insecure party can treat the contract as repudiated. A repudiation functions like a total breach by giving the non-repudiating party the immediate right to terminate the contract and sue for damages.